Assalamualaikum and hi, we are from Group 13B. Today, we would like to present about the effect of Section 5 of the Civil Law Act 1956 on the development of Malaysian law. Before we start, I would like to introduce myself and the team members. My name is AISHAH BINTI SAMRAEL and my matric number is 06683.
And my name is NURUL binti OMAR. My matrix number is 065461.
My name is ADILAH SHAHIRAH binti ALLAUDDIN. My matric number is 0670 and 23.
My name is IFFATUL Hanan binti Nordin and my matric number is 067549.
For the introduction, the first Charter of Justice is served as the first official introduction of English law to Malaysia on the island of Penang. This was issued by the British Crown in the year of 1807. Then, it has been applied to the adoption of English law in 4 states, which are Sarawak, North Borneo, Unfederated Malay State, and Federated Malay States. English common law and equity is officially adopted in the year of 1956 in Federation of Malaya, which includes Penang and Malacca after passing the Civil Law Ordinance 1956. This is subject to any modifications that the local conditions require. Civil Law Act 1956 emphasizes how English law should be applied. Section 5 of Civil Law Act 1956 governs the application of English law in commercial affairs such as insurance and business transactions. This section only allows the application of English common law in the absence of any written law passed by the Malaysian Parliament.
Now, I will explain a little bit history of the adoption of English law. Section 3, Subsection 1 provides the application of English statutes of general application, common law and equity principles with the exception of local legislation, cut-off dates and local circumstances. Statute of general application means the British Acts of Parliament that apply to all of England. The statute is received through the 3 legislation which are Civil Law Ordinance 1956 in Peninsula, Application of Laws Ordinance 1951 in Sabah, and Application of Laws Ordinance 1949 in Sarawak. The Statutes of General Application is the law that is unrestricted to time, and all the members of same class are subject to the statutes. The issue that arose is whether the English Statutes of General Application applicable in West Malaysia. There are 2 views regarding this issue. The first view is from Professor Bartholomew writing in Section 3, Subsection 1, Civil Law Ordinance 1956, holds that such English statutes are applicable. However, Joseph Chia expressed a contrary opinion in discussing the corresponding provision of Civil Law Act 1956, and judicial opinion supports Joseph Chia's view. Now I will talk about Section 5 of Civil Law Act 1956, which is also headed as Application of English Law in Commercial Matters. Section 5 is the statutory authority for the reception of English law, specifically in commercial matters. Section 5 Clause 1 provides that in the absence of any local written law, English commercial law shall be applicable in Peninsular Malaysia except for Penang and Malacca. On the other hand, as seen in Section 5 Clause 2, in the states of Penang, Malacca, Sabah and Sarawak, the English commercial law applicable will be the same as administered in England, the like case of corresponding period in the absence of any local written law. Section 5 used the expression law to be administered, which allowed the application of the whole of English commercial law. In that way, it is much broader than Section 3, which points to the specific sources of English law that may be used. Section 5 divides the country into 2 parts for applying English commercial law in the former Malay states, with 7 April 1956 as the cut-off date, so that English commercial law after the date is not the binding law. For example, in the case of Tan Mui Liang against Lim Sun San, the fact of this case is the appellant and the 4 respondents were partners in the business of dealers. The appellant gave notice of his intention to dissolve the partnership and subsequently applied for the order that the partnership is wound up, the taking of accounts and the appointment of a receiver. The respondents pleaded that the notice given by the appellant was ineffective in dissolving the partnership and that it amounted to a notice of intention to retire from the partnership. The appellant applied by motion for the appointment of a receiver and manager. The learned trial judge dismissed the action and the appellant appealed to the Federal Court. The Federal Court decided that since Part X of the Contracts Malay States Ordinance had made provisions for a partnership, this would constitute other provision as envisaged under Section 5 Clause 1 of the Civil Law Ordinance. Therefore, the English law of partnership does not apply. Now, we move to the next point, which is mercantile law. Mercantile law has been defined in Vulcan Match against Herm Jackson as the law on buying and selling merchandise. We can see in the case of Sangjit Hind against Nagodas Purushottam 1923, the issue concerning the law of sale is an issue of mercantile law. However, this issue arises again 10 years later in the case of Syed Sahid bin Abdullah Bajarai against Songkalingam Chetya 1933. In this case, the court held that the statutes were not part of mercantile law because they contain 7 clauses excluding from their scope. An issue raised under any of their provisions was not an issue concerning mercantile law. Consequently, the statutes did not apply in the Strait Settlement.
The difference between Section 3 and Section 5 of the Civil Law Act 1956 is that Section 3 authorized the use of English law in general. This section shall apply where further provision have been made or may be made by any written legislation in force in the Federation or any component of it. Next, the Court shall apply English common law and equity rules in force in England on the date this ordinance entered into force. As mentioned above regarding the common law and equity principle, however, shall be implemented only to the extent that the circumstances of the Federation state and their respective inhabitants allow and subject to such qualification as local circumstances need. Meanwhile, Section 5 is regarding the specific application of English law such as commercial matter. Stated in Section 5 subsection 1, it was applicable in Peninsular Malaysia except in the state of Penang and Melaka. This is because Penang and Melaka was administered in England on 7 April 1956. Additionally, Section 5 also stated that if there is any absence of any local statute, any English law that relating to commercial affairs will be applicable in the state of Penang, Melaka, Sabah and Sarawak. This is under Section 5 subsection 2 of the Civil Law Act 1956 as it was administered in England at the time of the dispute. Therefore, the applicability of English law in commercial matter, particularly in Penang, Melaka, Sabah and Sarawak, is broader than the general application of English law under Section 3 of the Civil Law Act 1956. Next is regarding the impact and effect on Malaysian law in commercial matter. Section 2 of the Sarawak Application of Law Ordinance 1949 and the Sabah Application of Law Ordinance 1951 provided for the receipt of common law, doctrine of equity, and legislation of comprehensive application as administered in England at the time of the respective ordinance type. Furthermore, Section 3 of the Sarawak Ordinance is the addition section to import English law in their state. This section deals with importing specific English statute listed in the Sarawak Ordinance schedule. However, the acceptance of English law in both states was limited to the extent permitted by local circumstances and custom, and subject to any qualification that local condition and native customs required. Further discussion is regarding the English law evolution. English law evolution must follow the guideline highlighted in Section 3 of the Civil Law Act 1956. This section is onerous section that offers the concrete approach that court should use when confronted with a lacuna. Dato' Abdul Hamid Muhammad J. described the correct methodology in the High Court case of Nepalese neighborhood and Jones Long Wooton. The court should evaluate whether the local circumstances and local inhabitants allow the implementation. If it deemed permissible, the court should enforce it. If not, the court may reject it or adopt any component deemed permissible, with or without qualification. The court is free to consider any source of law, local or elsewhere, such as common law or equity rules as applied in England after 7 April 1956, principle of common law in other countries, either from Islamic law of common application or common tradition of Malaysia. Hence, when there is lacuna in the law, the court must refer to English law, which must pass through this 3 obstacle barrier that has been specified in Section 3 of the Civil Law Act 1956 before applying it in Malaysia. There are cut off dates, local circumstances and resident. If English law clears these 3 obstacles, it may be applied by the court. However, if it meets these 3 requirements, the court may adopt a part of it with or without qualification or reject it entirely.
Next, I will continue the impact effect on Malaysian law in commercial matters. Section 5 and Section 3 are closely related clauses in the importation of English common law in Malaysia. In consequences, an issue arises in the matter of lacuna which is gap in the law. Malaysian courts should not turn to English common law but instead should look for local remedies within Malaysian legislation and courts ruling. Many judges argue that this clause should be removed from the Civil Law Act of 1956. Malaysia needs to break free from the constraint imposed by colonial common law and create its own Malaysian law. But the Malaysian Bar Council was adamantly opposed to calls for the measure for common law, whether through the repeal or cancellation of specific parts of the Act. The Bar Council claimed that rather than being seen as a weakness, Malaysia's use of English common law is a strength. It offers investors and companies doing business in Malaysia protection and predictability. The Bar Council also stated that Malaysia's connection to the common law through Section 3 and 5 does not restrict Malaysian courts from creating their own common law. The common law of Malaysia is automatically incorporated into English cases that have been upheld by Malaysian courts. The court is furthermore permitted to reject any English legislation that, in the court's judgment, it will not be consistent with the local conditions and population, either whole or in part. In a nutshell, the growth of Malaysian common law through Section 3 and 5 has been ongoing because the current legal system already permits its development. Any English law that has been fully or partially upheld by Malaysian courts becomes Malaysian common law. Accepting English law is acceptable as long as it is done following Section 3, Clause 1 of the Civil Law Act of 1956. In the recent cases related to Section 5 of Civil Law Act 1956, Abdul Rasa bin Senjata against Donna binti Itam in the year of 2022. The issue in this case is whether the deceased, which is the plaintiff father, had a mental illness at the time of the transfer of land and lacked the capacity to enter into a contract. Plaintiff had failed to establish on the balance of probabilities that defendant was aware of the deceased's insanity at the time of the transfers. Due to the fact that such transactions occurred before Sabah implemented the Contracts Act 1950 on July 1, 1974, based on English Common Law, Sections 3 Clause 1 and 5 Clause 2 of the Civil Law Act of 1956 permit the adoption of English law if there is lacuna. The court determined that no gap in the legislation would justify the use of English Common Law in this case.
From today's topic, there is one suggestion that we can give, which is no cut-off should be set to keep up with time. This is because common law and equity norms evolve through judicial decision, so it's challenging to discover the common law or equity law on the subject on the deadline. England has undergone significant transformation since those cut-off date, and the statutory law has changed and replaced the common law itself. Hence, it would be irrational for our courts to follow an English status that has since been modified in that country. Furthermore, a lot of topics listed under Section 5 have already been controlled by Malaysian local statute, so automatic acceptance of the common law as it existed on the start of date should be repealed, as this law might be outdated and no longer enforceable in England. In conclusion, the common law concepts can still be used and applied in Malaysia when there is a gap in law or an uncertainty, as Malaysian constitution was drawn by using common law principles. That's all from us. Thank you.